Welcome back to Great Days. We welcome Michael Jankins at the desk with us right now as we are talking bankruptcy here this morning and learning things about it you never would have known about. It wasn't for this man right here. You're putting it in plain English, which a lot of people appreciate.
Well, today we're going to finish up a topic that's been going over the last three segments, how bankruptcy law intersects other areas of the law. And so today we're going to talk about personal injuries. People will sometimes had a car wreck or had a slip and fall and gotten hurt really bad, and then they also need to take bankruptcy. It seems that bad cloud follows people along. If they have troubles in one area, they have other troubles. But
so they have two things going on there, right?
So in the old days, 15 years ago, people couldn't protect their claims for personal injuries when they filed bankruptcy. If they had one and they filed, they would have to give up at least most of the money to the court to pay their debts.
Really?
And
I didn't know that.
They changed the law probably 7 or 8 years ago on property that we can protect in Iowa, and said now we can protect personal injury claims too, but they put a caveat on it saying to the extent that it's reasonably necessary for the support of the person that's filing bankruptcy or their family.
Okay.
So that still left a little bit out there going, well, it's not always protected, and if it's not always protected, when isn't it protected? We don't know.
It seems kind of vague.
It's very vague.
Necessary, yeah.
And that makes it difficult for us as practitioners on what to advise people, because most of the times that I've had it, well, actually all the times, we've gotten it so that the trustee of the bankruptcy allowed the protection for the personal injury.
Okay.
A lot of times if it's a fender bender or just a whiplash type injury, nothing catastrophic, they're letting those go through. It's not going to be lots and lots of money. And I think sometime, based on the questions they ask, if somebody was going to be getting a lot of money, they might try to object saying, well, you know, that's not reasonably necessary. It's more than reasonably necessary for their support, and maybe they should have to pay some of their debts. But this issue really hasn't been flushed out in the bankruptcy court. There's really been no decisions that I'm aware of by our judges in Iowa kind of saying when it's protected and when it's not. And even if they did, I'm sure it would be on a case-by-case basis. There's not going to be some definitive case that's going to go, this tells it all for all the different cases.
So that threshold has not been met yet in any of these cases that have used this? Okay.
So it's kind of difficult as practitioners. What do you advise the client to do? But so far, it's worked out for any of the cases I've had. So, but it's a difficult issue, and it's one that, you know, it gets a lot of discussion when the client comes in. What should I do? We definitely have a lot of discussions with the person's attorney that's representing them in the injury case. Now, on the other hand, in the area of injuries, there's also workers' compensation or work injuries.
Right.
Now, those have always been protected under the law. So if the person comes in and they injured their back at work and had to have back surgery, and they're going to come into some pretty good chunk of money, those claims are protected. That's kind of how it's always been. There's not this other standard about, oh, if it's reasonably necessary for the person's support. So as long as the claim is still pending and they're not sitting on the money, the claim itself is protected. Now, as to whether the money, once they get it's protected, that's sort of up in the air too. It's never been definitive by the different decisions that have been made on this. It's not been an issue that's come up a lot. And so there's always a kind of a problem if the person is all of a sudden ready to settle, and the attorney that's handling the workers' comp all of a sudden gets it all done and the person's sitting on $25,000, that can be difficult. I don't know with the trustees if they'll accept that as protected or not. A lot of the logic behind some of the other exemptions in the cases on other property protections would suggest it is, but as the attorney having that kind of case, you don't really want to be in that position to have to defend the issue, because you don't know what the answer is going to be, so there could be some risk. So when the person comes to me, we tell them, don't have your case settled before you file your bankruptcy. Make sure you tell your other lawyer, I'm looking to file bankruptcy. My lawyer needs to talk to you.
Okay.
So tell them to chill out for a while.
Well, to hold up a little bit,
Yeah,
because those things ordinarily take a lot of time to resolve anyway. I mean, all these claims for injuries, they don't move very quickly.
Now, what about what if somebody has been involved in a workman's injury type situation and they have settled, with the company and they are getting payments because of the settlement? Are they still able to file bankruptcy and still have their payments come in, or will those payments be taken away part of the payment?
In those cases where weekly payments are being made, which is in some of the cases, because some pay out weekly, some pay out a big lump sum all at once, and it would probably be the same issue as when you are being paid a lump sum. You're starting to draw the money, but it would probably be a better argument in protecting it if they're being paid out in weekly payments, because you're not getting all your money at once, and so you would probably be able to protect those payments. But again, it's an issue that's not 100% certain, but I would think that it would be protected.
Okay.
I personally think that if you get the lump sum, it would be protected, but I don't want to be defending that position because it's an uncomfortable position to have to defend since we don't have a concrete answer on it.
What happens if the injury occurs after you've started proceeding with a bankruptcy?
Well, if you've already filed your bankruptcy, the events that occur afterwards are not part of the bankruptcy. So the bankruptcy sets the date. The date you file, it's relating to things that occurred previous to the filing.
Okay.
Now, the only exception I mentioned earlier segments is if you have an inheritance, because that goes to 6 months after.
Right.
Or a property settlement in a divorce, that goes 6 months after you file.
Okay.
But in all other instances, the property rights that are arising are those that were created before the filing date.
Okay.
So if you got injured one day after, or a car wreck one day after, those aren't going to fall within the bankruptcy problems.
Got it.
Or winning the lottery.
I was going to ask that.
Which I actually I had a client.
Did you
that
really?
Won Powerball. At the time, I think it was one of the biggest ones, and it happened after. So a lot of thought went into what should be done there, but it was after, and so it wasn't part of the case.
Gotcha.
Really?
So that made a real interesting issue because there was lots of money.
Wow. Interesting.
More than I've ever seen.
All right. How about that? All right. So if people do have any other questions about this and they want to get a hold of you, what's the best way to get a hold of you?
They can call me at 255-1855. We can talk to you on the phone, or you can find us on the internet at www.iowa-bankruptcylaw.com.
There you go. Perfect. Well, wonderful. Well, thank you very much. You put it in plain English. I appreciate that so
Thanks.
much.